Welcome, everyone. My name is Michael Needle, and I'm the 3L president of the Iowa Federalist Society at the University of Iowa College of Law. Tonight, we are here with the Federalist Society's Professional Responsibility and Legal Education Practice Group to discuss the ethical and responsible representation of unpopular clients. The Federalist Society's 15 practice groups are organized by substantive areas of law. Each group is led by a chairman and executive committee comprised of top lawyers from across the country. They meet each month to organize in-person events, webinars, publications, and panels for the Federalist Society's flagship event, the National Lawyers Convention. You can learn more about the practice groups at fedsoc.org/practice groups. To have the critical conversation we're having tonight, we're joined by Minnesota Supreme Court Justice G. Barry Anderson. Justice Anderson graduated from Gustavus Adolphus College with a bachelor's degree, magna cum laude, and the University of Minnesota School of Law with his JD. Post-law school, Justice Anderson served as a city attorney for over a decade, being certified as a civil trial specialist by the Minnesota Bar. Justice Anderson has also served the Minnesota community, leading public television access efforts and a youth athletic coach, with, I'm sure, more wins than Don Shula or, for younger audiences, Bill Belichick, and advanced civic education nationally as well, serving as a judge for the We the People High School Civics Competition. In 1998, Justice Anderson was appointed to the Minnesota Court of Appeals, holding that position until 2004, when Governor Tim Pawlenty appointed him to the Minnesota Supreme Court. On behalf of the Federalist Society, Justice Anderson, welcome, and thank you so much for your time. I just want to give a brief comment about the event structure. We'll have about 12 minutes of remarks from Justice Anderson, followed by some questions I've prepared. Then, with the time we have left, we'll move to audience questions. Audience members, please use the Q&A feature at the bottom of your screen for submitting questions. And with that, Justice Anderson, take it away. Thank you.
Michael, thank you for that introduction. I do want to make one little correction. If you're going to introduce a member of the Minnesota Supreme Court, you don't make reference to Don Shula and certainly not to Bill Belichick. The appropriate reference is to the late Harry Peter Bud Grant, who took the Minnesota Vikings to 4 Super Bowls, and they should have won at least 2 of those. But anyway, that's a story for another time. I'm delighted to be with all of you today, and we're going to talk a little bit about the duty to represent the unpopular client. I do want to say that the actual title here, as far as I'm concerned, is defending the unpopular client. The question of whether or not it's a duty is an interesting one because there's some argument among academics about whether or not, in fact, lawyers should represent clients that whose views they don't agree with. I answer that question one way, other people answer it another way. It's maybe more accurate to call it a norm. But whether it's a norm or a duty, we're going to talk a little bit about it today. And we're going to begin with perhaps the most famous episode of defending the unpopular client in American history, the defense of British soldiers in the Boston Massacre. Next slide, please. So I'm sure most of you know the story, but it's worth repeating. What you're seeing on your screen now on the right is Paul Revere's colored version of a drawing, no photographs in that era, of course, of their depiction of the common depiction of what they saw in the Boston Massacre. On the evening of March 5, 1770, British troops fire into a crowd of angry American colonists. The tensions between colonists and the Brits were increasing, and as a result, 5 colonists were killed, including a middle-aged sailor and rope maker born of African-American and Native American descent known as Crispus Attucks. Some argument among historians whether he was the first to die, but certainly he was a symbol for African-American struggle for freedom and equality. And Attucks was afforded honors that everyone else involved in this was also afforded and probably rarely offered to a person of color in that era. Sam Adams organizes a procession to lay the victims in state for 3 days before a public funeral. I mention all of this because it's one thing to talk about the subsequent representation by Adams of those soldiers and say that it was bravery and that it was remarkable, but it's important to understand the full context of the anger over this event. There were an estimated 10 to 12,000 people, perhaps more than half of Boston's population, at least according to some historians, who joined in the procession that carried the caskets of Atticus and the other victims to the graveyard. So we know, I'm not going to go into the trial itself. That's deserving. And in fact, there are some really fine podcasts that discuss that at some length. But we do know that as a result of the vigorous defense that John Adams gave, that all but two of the soldiers were acquitted, and the two that were convicted of lesser charges. Next slide. Adams himself says that the part that he took in the defense of those soldiers was perhaps his greatest service to his country. And he said that on multiple occasions, and it was something even late in life. He was of the view, the importance of a lawyer representing an unpopular client. Next slide. So we talk often about defending unpopular clients, and where this comes up often, and we'll see that in a couple of cases here moving forward, but where that comes up often is in the criminal law area. And certainly when you look at our constitutional provisions, Fifth Amendment, no person shall be compelled in any criminal case. You can see why to testify, you can see why representation is important. The Sixth Amendment, providing that the accused shall enjoy the right to a speedy and public trial. And then finally, the 14th Amendment, guaranteeing due process of law and the equal protection of the laws. And as we know, in Gideon versus Wainwright, the United States Supreme Court recognized the requirement that in serious felony cases, representation is required. Many of you will probably someday serve in either a prosecution or a public defender role. We take that for granted. It's actually a fairly recent innovation and very necessary. Next slide. So I mentioned earlier that the calling this a duty maybe overstates the case a little bit. I think it's a duty, but I don't think it's necessarily a legally enforceable duty. I'm not aware, certainly I have not been able to find any instance in Minnesota where a lawyer was accused of a discipline violation because he or she did not represent somebody who was controversial. But as far back in terms of official documents as 1958, the ABA recognized that this is one of the highest services a lawyer can represent or can provide. And then this next reference on that slide to the model rule, a lawyer's representation of a client does not constitute an endorsement of the client's political, economic, social, or moral views or activities. I'm going to talk a little bit more about that model rule here. Most states have adopted some version of that. There are a handful of states that have not. The academic discussion, and we only have a limited amount of time this evening, and I'm not going to highlight that for you. You can go to the various journals, and everybody watching this presentation is a better researcher than I am at this point in my career. You can find the academic argument about whether or not a lawyer has a so-called duty to represent an unpopular view. But my take on this has always been, if you don't take that responsibility seriously, and if instead you confine your representation of clients to people with whom you agree and with whose positions you agree, then is in fact your representation effectively an endorsement of the client's political, economic, social, or moral views. In other words, if you loudly proclaim to all concerned that if I don't agree with you, I'm not taking your case, are you saying every time I take a case, I agree with you? That maybe is more dangerous than representing clients with whom you might disagree. Next slide. So lots of historical examples. We won't spend a lot of time on this. Edward Bennett Williams, more famous as the owner, I suspect, of the Washington Football Club, but also representing some folks with some interesting histories. Clarence Darrow was referred to in one biography, the title of the biography of Clarence Darrow as attorney for the damned. He was willing to take on some very unpopular clients, usually in the context of criminal prosecutions. Next slide. And then you have lawyers with clients that were unpopular at the time, but now you'd be hard pressed to find anybody who thinks of them as unpopular. Thurgood Marshall, for obvious reasons, distinguished career as a litigant in the civil rights area, and then as a member of the United States Supreme Court. Fred Gray, who represented Rosa Parks. And I want to say a word about Roger Taney, of all people. Roger Taney, of course, we know him as the author of, the worst decision in the history of the United States Supreme Court, the Dred Scott decision. But in an earlier iteration of his life, he represented an abolitionist Methodist minister from Pennsylvania by the name of Jacob Gruber, who was accused in a camp meeting of having condemned slavery in bitter language in Maryland, which was a slave state, and was indicted as an inciter of insurrection. Taney defended Gruber at some personal cost and ultimately secured a not guilty verdict. You may ask, and I think lots of people do ask, what happened to that Roger Taney? A far better person than the one who wrote the Dred Scott decision. Anyway, next. So most of you watching this presentation aren't going to have probably famous clients, but you are going to have unpopular and controversial clients. And I can tell you from my own personal experience that that's the case. And they're going to come in a variety of ways and with a variety of claims. You may represent somebody who is in a very contentious divorce and maybe engaged in behavior that was inappropriate. You may represent real estate developers who are often in contentious situations. Dram shop defense, defending individuals who are accused of just horrific, being responsible for horrific accidents, causing horrific damages. I did some of that work. May talk about that a little bit later. Of course, criminal defense, we all know about that. And unpopular local businesses. You think of landlord-tenant kinds of disputes. All of these are situations where these aren't high visibility kinds of individuals. You're not necessarily going to get a line in some academic work for having represented, as some lawyers have done, people who have particularly egregious views, but nonetheless, they're unpopular and they may be difficult clients. Next. Three things that you need to keep in mind when you're representing individuals like this. If you work for a law firm, you don't undertake a representation like this without some advanced discussion with your partners. You don't blindside the people you work with, and some law firms may choose not to permit you to represent people. And of course, we've seen some of this in recent years with issues that are unpopular with prevailing academic views, representation of individuals in various fields, and law firms have chosen not to get involved in those. Doesn't necessarily reflect well on the law firms, but that's a firm decision that they get to make. The second point I would make is don't make the problem worse. And you need to diagnose the problem in order to avoid that. And then third, and here I wish you the best of luck, encourage the clients not to make the problem worse. And this particularly, I have some background in family law. This is sometimes difficult to do. We will save the details for some other time. Next. What do you do when you have one of these clients? Unpopular, controversial. I think the first thing you do is you tell the client that you need to know the whole story. There needs to be honesty, and you need to tell the client that your representation is confidential. I think it's also useful to depersonalize the relationship. If you're adverse to the client on political or philosophical grounds, I think one of the things you tell that client is we're not going to discuss those issues. My job is to represent you professionally, not to get into an argument with you about issues we don't agree and which don't affect my representation of you. And then one of the things you have to think about if you've got a client with significant issues significant ramifications for that client's career or business, and there's enough money to make this work, do you need to hire somebody who does crisis management work? You know, years ago, 30, 40, 50 years ago, you know, a lawyer might offer the crisis management advice. Maybe you're qualified to do that, or maybe you need to get somebody who is in a position to provide some useful advice about what that might look like in terms of dealing with crisis management. Here's an example of this. The normal advice that I was given to give to clients in a difficult situation, particularly where there might be criminal law complications, is don't talk, don't say anything. You know, don't put yourself in a position where you might be a witness or something might be said that would contradict what you have said earlier. Well, that's all well and good, but if the client's multi-million-dollar business, or even you know, the client's entire career is online, maybe the client is willing to run that risk, but you do that only with appropriate professional advice in dealing with our much more complicated social media environment today. When I started practicing in 1979, you worried about the local newspaper and the local radio station, and that was probably about it. It was unlikely it was going to go any further. Next slide. I think the advantages are sometimes hard to see of representing unpopular or controversial clients. You know, the rewards aren't always there, don't appear to be there. There can be complications, as there have been for a number of, you know, well-known publicly identified lawyers who have represented controversial clients, and have wound up having to look for different firms or to join other firms. So there can be costs, and the rewards might be hard to identify. As I indicated earlier, you know, one of the things you worry about is the possible public identification with the client, with you, in terms of your, in terms of people seeing your views as the same as the client. If you have a reputation for taking on tough and difficult clients, it's a little easier maybe to avoid that public identification. Next slide. So, as a way of to sort of conclude the conversation that we're having today, you know, there are complications sometimes in representing difficult clients, but I think it's always important to understand that the American system of jurisprudence, built on the British system of jurisprudence, which includes a very long requirement that trial lawyers in Britain represent all comers, even if they don't agree with those individuals. And that's a public norm that's recognized. I mean, I think that still exists here in this country. You're not in the same position as the great French philosopher and lawyer Malesherbes, and I'm mispronouncing this. Those of you with a French degree can help me with that. I looked up the pronunciation today and I still couldn't get it right, so we're not going to worry about it. But he was the great grandfather of Tocqueville, who of course wrote Democracy in America and is well known to students of the American founding. And he thought that in the course of the French Revolution, the king, Louis XVI, deserved representation. He provided it, and ultimately Louis XVI was guillotined, and a few months after that, so was Malesherbes. So we don't have to worry about that. It's not that kind of cost, but I do think, and I do encourage you to pay attention to that norm of representing the unpopular or controversial client. I think it's in the best traditions. It's in the best tradition of our legal profession, and I have little doubt that all of you will be willing to uphold that tradition. So those are my prepared remarks, such as they are, and I'm willing to take some questions.
Well, Justice Anderson, thank you so much for your reflections. I can't speak French either, so I don't think I could help you out with the pronunciation of the last name. I did want to ask you to start. You mentioned in one of your slides a little bit about eroding norms over time. And I just wanted to ask you a pointed question about over your legal career as a lawyer and a judge. How has representing unpopular clients changed over time, being more important, less important, more unpopular, more popular? What are your general reflections on that?
Well, I want to be careful here because I think people sometimes see this in political terms. I think some argue that there is less tolerance for representing the unpopular or controversial client, and they'll point to some well-known publicly acknowledged incidents where lawyers representing, particularly in civil matters, controversial or unpopular clients, you can think in the abortion space, in the gun space, and without making any judgments about any of those issues specifically, some law firms have made it clear that they don't want to get involved in representing people who might be defending the pro-life or the pro-Second Amendment kind of analysis. But what I would say about that is I think there's some recency bias too, because I think if you go back to the 1950s and 60s, there were lawyers representing unpopular clients in the who publicly identified as communists or socialists. There have always been challenges to lawyers who serve in the public defender space representing defendants accused of particularly heinous crimes, and you can see some of that even today in some of the prosecutions in the last few years. So I'm a little cautious in saying the problem is worse. I think it might be worse, and I think one of the reasons it might be worse is I think that as law firms have grown in size, you now have firms that exceed 1,000 lawyers. I think the sensitivity factor has become more of an issue. On the positive side, we now have law firms representing clients, and small law firms representing clients in a wide variety of areas. I think about the New Civil Liberties Alliance, Alliance Defending Freedom, Gender Justice. There are environmental groups. All of these organizations, and they span the ideological spectrum. Those options did not exist as a practical matter 50 or 75 years ago. The problem, of course, is those firms are very careful about the cases they take. They want to take cases that aren't going to be mooted out or run into other problems, and that leaves some people without access to legal representation, and that's a problem. I noticed we had a question come in that somebody was wondering about seeking out work in this area. I think that is I think you have to have a high tolerance for being disliked, but I think that is a potential career opportunity. It's you could see some examples in the recent past of that. The problem, of course, that a lot of those cases require, financing those cases can be really difficult, and for solo and small law firms, that's very problematic. Next question.
And I just wanted to ask, bearing in mind we're discussing ethics tonight, and one of those duties is the duty of confidentiality. I was wondering if you could share, to the extent you're able to, maybe examples from your career as a lawyer advocating on behalf of clients when you've experienced the unpopular client and what that actually looks like on the ground.
Well, I represented municipal government for 11 years, and on various occasions, those decisions were unpopular with people. I earned some letters to the editor and matters of comments like that. But I would say, from my perspective, part of my civil litigation practice, I did both personal injury and defense work, but part of my defense practice was in the dram shop area. And for those of you who are unfamiliar with dram shop liability, basically it's centered around excessive consumption of alcohol, in which persons serving a person who has consumed too much alcohol are held responsible and for money damages. These cases are, you don't see simple or easy or low injury cases. The injuries are almost always tragic, with generational kinds of damages, moms and dads and kids. killed in, usually, but not always. You can have them in other contexts, but automobile accidents and things of that sort. And, when you're in the position of defending the bar or the server, you aren't necessarily seen as performing a societal good. But, in fact, those institutions are entitled to a defense as well. I also handled, I had some experience representing landlords in a college town. And for those of you who have had landlord issues, I wasn't all that popular there either. So so I've had some experience. Nothing that's going to get me on anybody's PowerPoint slides in the future, but I at least I understand the emotional cost there.
I wanted to shift before we go to the Q&A, and the Q&A is filling up now. But I wanted to ask you about your work with the Federalist Society practice groups. How long have you been involved in its work, and how can recent grads or law students that haven't graduated yet get involved with what they do?
So the way to do this is volunteer. Find somebody who's participating, and if you're interested in volunteering, actually, send an email to Mike or me, and we'll find something for you to do. I would encourage, you don't need to go every year, but I encourage attendance at the National Lawyers Convention, which is always good. We have regional meetings. My own personal involvement, when I graduated from law school in 1979, Federalist Society didn't exist. No organization like it existed. It was just coming around. I like to say that if the Federalist Society had decent records instead of the mess that they've had from those early years, I would be effectively a charter member. I joined as a lawyer practicing in Greater Minnesota. This is the old days, no internet. I got a thing in the mail saying there was this lawyers group organizing, and it looked like something that I was interested in, and I sent in my $5 or whatever it was, and was on the roll. There's actually kind of a semi-funny story that when I was appointed to the court by Governor Pawlenty, one of the local radio stations was on the hunt for Federalist Society members, and they called me up to find out about this dangerous organization that I joined, and I told them it's basically a glorified debating society. And in fact, it doesn't take stands on public issues, and although this wasn't the topic of conversation then, as many of your viewers know, Federalist Society doesn't file amicus briefs. I've never been at a Federalist Society event where both sides or multiple sides weren't represented. If you can't find other points of view, you're not getting on the platform. And by the time I was done explaining to it, I think they lost interest. There was no story here. So, so that's been my involvement, and I encourage people to participate, and really, I think sort of participate at the state and local level. I think that's something we really need.
No, absolutely.
We being the legal business, the lawyers, as well as the Federalist Society. I think opportunities like this. I don't discourage people. I mean, I've been a member of the Minnesota State Bar Association from the time I started practicing. I realize there are controversies with the ABA and all that, but and I'm not minimizing those, but I think we are better as lawyers the more connected we are in community with a variety of different ways, and the FEDSOC is just one of them.
No, absolutely. I want to turn to audience questions, if I can, Justice Anderson.
Fire away.
So one question is, what are some good examples of representation of unpopular clients that you've seen in your courtroom, either as a judge on the Minnesota appellate courts or at the Supreme Court level? Well,
the first and most obvious answer to that question is our public defenders. We have a very sophisticated and an excellent public defender system in Minnesota, and our appellate advocates are very effective. And, we're going to have arguments in another week or so, and we'll have arguments in June, and there will be some attorneys representing people who are accused and convicted of, among the most serious crimes committed anywhere. So I think that's the most obvious answer. But I also have to say that we've had situations where we've had parties where we've had a party who isn't represented. We have had a couple of family law matters like this, and we've appointed lawyers we've asked the Bar Association to appoint somebody and then recognize them as having been appointed. And that's, when the question was asked earlier about possibly seeking out clients. I mean, this is one thing that is often a need, particularly in the appellate practice, because there may or may not be an appellate lawyer available for a variety of reasons, particularly in a civil case. And often courts are looking for somebody to represent somebody who has had difficulty finding lawyers for obvious reasons.
No, absolutely. There's one question related to a part of your presentation, Justice Anderson, where you mentioned the implicit imputation of a client's view onto a lawyer who only takes clients to whom they agree. What would you say are the possible harms that could come from that kind of implicit endorsement of the politics behind cases? And what advice would you give to a lawyer who might think, I only want to represent people that I agree with?
There's a value judgment here, and I'm not necessarily telling people what they should do. I'm just simply pointing out the possible consequences. I mean, if you're going to take that position, then you're going to be deprived. You're going to be deprived, and people are going to be deprived of the opportunity to represent clients who might, need representation. I'm thinking many years ago. I was active at not at any great extent, but I mean, I was involved in Republican politics, and I remember serving on a committee organized by the state party organization. And there was a question about someone who thought they had been deprived of service on one of our committees, or the details aren't all that important. But the lawyer representing this sort of internecine Republican dispute was someone who'd been actively involved in Democrat politics, but was widely regarded as a very effective advocate. And I remember talking to one of my colleagues, who we were on this committee, saying, "Well, what's he doing there?" And I said, "Well, the guy with the complaint went out and hired somebody who was the best in his business, and didn't ask a lot of questions about, whether or not they voted for the same people." I think that's a great endorsement of that lawyer. I think the principles are long gone now, but anyway, the point is that you can take that position, and I'm not even saying it's wrong. I mean, I think it's a decision, it's a judgment call that everybody makes. But I'm thinking it might deprive you of opportunities you might otherwise want to have.
No, absolutely, Justice Anderson. We have time for one more question. I wanted to, from the Q&A portion, you mentioned a little bit during your presentation of ways in which a lawyer could depersonalize the relationship to sort of mitigate tension with things that exist outside the case. The question is, how do you know when it's time to, quote unquote, let go of a client? When's it clear that that kind of mitigation effort wouldn't be effective?
So this is one of the most, that is a great question. It's one of the most difficult questions that practicing lawyers face, because there's no rule written down anywhere. There's no, it's kind of life experience, seat of the pants experience. You've been there before. And you're probably going to make some mistakes in this regard before you finally figure it out. But I think it's just a function of when has that relationship, for whatever reason, broken down to the point that it just can't continue. And you have to make judgment calls about the people you're dealing with and the circumstances, and try to figure out whether you can make it work. And sometimes you can't. And I talked earlier about how this question about whether or not it's an official legal duty. That's a that's a doubtful proposition. But you do have duty issues and potential ethical problems in withdrawal circumstances. In fact, you may not be able to withdraw for example, in some criminal cases, depending on the spot in the criminal procedure process that you're at. And it may be that issue is presented elsewhere as well. So, I wish I could give better advice here. I can't. You simply have to be alert to, those complications. And I think one thing that comes up, if you and the client have agreed that the client's not going to call press conferences and rant about the evil person on the other side, and that agreement isn't being followed, well, that maybe tells you something. It's you've got the unpopular client, you've got the controversial client, and you got the difficult client. And if you got all three of those things together, life could get interesting.
No, absolutely. Those are my two favorite law school answers. You know it when you see it, and maybe it depends. But with that, Justice Anderson, again, thank you so much for your time. Thank you too to the Federalist Society practice groups. One more comment I'll make is I want to briefly employ everyone to tune in next week for another practice group presentation on the importance of amicus briefs in IP litigation, co-hosted with the Berkeley Law Federalist Society.
Okay, so now I have to jump in and say those amicus briefs are really important, and I agree with whatever they said next week or are going to say next week about it. They really are important.
That is duly noted, and it's been recorded, Justice Anderson. Thank you so much. I hope you take care.
Thank you.